this.
Are we
Yeah,
recording?
you're ready.
Okay. Hello, my name is Ken Vercammen, and this is our semi-annual update on wills, probate, estates, and I always like to have it while I got a crowd of law students that are trying to get learned so they can be smarter than me and take my business someday when I slow down. Things have changed in the past year and a half because we always used to insist that everyone come in and then they would fill out a form by hand and take time off of work. And then last year we decided, we said, what, it's easier if people just email stuff in. So when COVID hit, we didn't have to change that much. And it kind of made it easier for everyone because no one was coming in. We were preparing the documents. So first we want to talk about, though, if people don't have a will. Or the will is declared invalid because someone used some cheap online thing and it wasn't signed right or it wasn't done right. Well, the procedure to distribute assets becomes much more complicated. I got some of my law students have worked on a state administration where it becomes more complicated. That means every one of the beneficiaries has to sign a renunciation saying, I don't want to be the administrator, and we pick one person. That's kind of, you think that that'd be easy in theory, but when there's, let's say, cousins and nephews where there's no will and someone doesn't sign it, then instead you got to file a complaint or to show cause to ask that the court allows someone to be the administrator. Whenever you go in front of a superior court judge, I tell people plan on spending $3-4 grand. It's not easy. Also, there's no will. Or the will was not done properly. There's a thing that has to be taken called a surety bond, where someone has to pay a fee to a bonding company. It's kind of like an insurance policy that says that you don't have to, that if you steal the money, they'll pay it back. So, number 3, there's additional fees within administration. Number 4, if there's no spouse, children, close relatives, conceivably the state of New Jersey will get the money. Who on the planet would say, I worked really hard and I want the government to get my money and not a charity or friends nearby? I'd say if we even recommend if someone has minor children, that means that a stranger determine who gets custody of any minor children. I used to say a bald white guy in New Brunswick, and now it's sometimes a lady judge. But more importantly, if someone doesn't have documents done properly, it causes aggravation in fights amongst the family. So if someone is, when the family's grieving, there shouldn't be one more thing to do. Logistically, what we've done in our office is make it easier. Someone calls our office, this is what a lot of attorneys do now, we email it a questionnaire and someone types in who's executive 1, who's executive 2, who's getting their things, and you always want to plan for a contingency. If it's going to kids, but the kids, one of the kids passes, who gets it? We get the form, we spell check it. I call everyone, when I'm driving, call with the hands free from the car. We open a file, someone doesn't even have to come in. They mail us a check or they pay by credit card. We prepare the documents and then we email it to everyone. And then we say, listen, if everything is good, print it out, and we give instructions on signing them at the UPS store or another place where there's a notary. There's a lot of people, they say, I can't, I'm only available on the weekends. Well, I'm not coming in to sign wills on weekends. Like, I work in the city, don't get back till 7 o'clock. Well, then people can do it just through signing at the UPS store. So the procedure we try to make as easy as possible for most people. So in the questionnaire, I mentioned, someone's going to type in their name, and now we also, in our form, recommend everyone have an up-to-date PAB attorney, up-to-date living will, because there's been some changes in the law. Now we have to be sure that the person who's signing, or that the document we prepare for someone is what they want. Sometimes kids call for their parents. I go, listen, I understand that you want to help them out, we'll send out the form, but I need to speak to the actual parent and they have to tell me over the phone, what they want. We also, then the form also asks who's executor one, who's executor two. You never wanna have joint executors. I tell, it creates twice as much work. Just this weekend, I was talking to a nice lady, and she goes, I wanna have both my kids join. I goes, no, see, that creates more work. That means that two kids gotta sign every check, even if they're identical twins living in the same house, that's creating more work. So it's better to have an executor one than an executor two. Because everything along the way, that if there's joint executives, that means two people gotta fill out the paperwork for the surrogate, two people gotta meet with the realtor on a contract, or the listing, two people gotta sign every contract, two people gotta sign an addendum, two people have to go to a closing, two people gotta do everything. A lot of times I explain to people, that they say, when can I come in and meet with you? And I go, okay, are you married? Yes. Do you want everything to go to your spouse? Yes. The day after it goes to your kids, correct? Yeah. Are you looking to disown anyone? They go, no. I'd say, then you don't really need to, unless you're looking to disown people, you don't need to meet with me before we start, because I also told people, believe it or not, New Jersey actually reduced some taxes. They did away with the New Jersey estate tax a year and a half ago. Inheritance taxes, no inheritance tax if it's going to children, grandchildren, stepchildren. If it's brother or sister, it's only the first $25,000 is tax free. So I smile and ask people, okay, we have to do some tax planning if your assets are more than $11.7 million. You got more than 11.7? They say no. Okay, then we don't need to do sophisticated tax planning. I also mentioned the thing on the executors, why you don't want to have joint. Sometimes you get two people that don't agree upon even, on anything. We had these two brothers. One brother would say the sky's blue. The other would say, no, the sky's gray. You're stupid. You've always been stupid. I remember the judge when we went to court saying, fellas, there must have you had some good times when you were kids, like going camping or whatever. Why don't you guys go have a cup of coffee and not be haggling over chairs and couches? Now, even though a will is done, there's certain assets that don't pass under the will, but they go by contract. So what are some examples of that? I'd say, well, if someone owns a house, for example, I'd say oftentimes the house is like if it's on husband or wife, automatically goes to the surviving spouse. There doesn't need to be a new deed. Other assets pass by way of contract. So think of by the way, another thing that passes by title is if there's a bank account, it's POD or joint, that goes outside the will. Other assets pass by contract, life insurance policies, 401k, anything that has a beneficiary. So I also suggest to people, unless you're 1,000% sure, you can get a printout from the company and put it in your will file. I was married for a decade, and I found out one of my policies didn't have my wife on it. It was my dad. And now also, if someone's leaving money, if there's a possibility the grandkids might get it and they're under 21, you want to have a clause saying they don't get the money when they turn 18, because otherwise they automatically get the money when they turn 18. We want to have a clause saying they don't get the money until they're 21 or 25, but the money can be used for college, maintenance, etc. Now, some people don't want monies going directly to spouse. The common example is if it's a second marriage situation, the person says, hey, listen, I'd say, I care about spouse number 2 or spouse number 3, but I got my own kids and my own blood. And sometimes I'll even say when I meet with people, I goes, okay, we can set up a will where it goes into a trust within the will for the benefit of that spouse, and then after that it goes to the kids. It goes, oh well, I'll just leave it directly to my spouse, and that they'll do the right thing. He goes, well, that's what you're hoping, but you don't really know that. But here's the other thing. I go, let's say your spouse gets married again. They could do a new will and leave it to their new spouse, and everyone says, well, neither of us would ever get married again. And I said, well, 25 years ago, you weren't being married, plan on being married a second time either, but you're both here. And I'm not anti-marriage, but I tell people that are contemplating getting married again when they're older, I go, do you understand that if a spouse goes to a nursing home, once that spouse's money runs out, then what's called a community spouse is responsible for that person's care, after a certain amount, even if they have a prenuptial agreement. If someone doesn't have a will and there's minor kids, they get the money automatically when they turn 18. So the idea with grandkids, younger people, we want to protect them from evil. See, evil is their friends that want them to rent a house for the summer down in Seaside, buy beer, etc. Guys are susceptible to whatever girl they're dating at the time. You haven't bought me any nice jewelry for a while. If there's minor children, we usually have a clause that says, who's a trustee 1, trustee 2, a guardian 1, a guardian 2. A law was changed in New Jersey where to make it easier to admit wills to probate. Older wills, and under the old law, it means that the person signs, then the 2 witnesses sign, but then one of the witnesses had to sign an affidavit with the surrogate saying, I was the witness. I remember when my grandmother died, one of the witnesses says, yeah, I'll sign an affidavit, my fee's $500. My dad goes, we're not paying you $500. He goes, we'll get the other witness. Well, that person's dead. We had to pay him $500 just so we didn't have to go to court. The new law, which the person signs, it's called self-proving will. The person signs, 2 witnesses sign, the attorney or notary signs, and then everyone signs again with this self-proving language. So it's important, if someone already has an old will, is it a self-proving will? Otherwise, get a new one done. Because the whole idea by the legislature want to make it easier for people. There's 5 main types of wills. We usually say, the typical, I call it the leave it to beaver will, where everything's going to spouse, children, grandchildren. Sometimes people have a will where it's going to, where there's minor children, so we put in testamentary trust for minor children. Sometimes people don't want to leave money outright to their spouse, and that's a way to protect some of the money from nursing home Medicaid. Set up what's called a testamentary trust for the spouse or a second marriage, and then of course let's say someone doesn't have children, who's getting the stuff, and if money's going to a charity, we always got to put a clause in that says if that charity ceases to exist, who would get the money? Because the chancery judge in Monmouth said, she had a week-long trial because it went to basically a charity that really didn't exist. Let's say we went to the AARP. Well, which group? It wasn't AARP, but so you want to be specific. Sometimes we even put in addresses. People sometimes ask us about getting a trust done. Well, believe it or not, New Jersey's the probate easiest state. In New Jersey, to probate the will, all that we have to send to the surrogate is the original will, death certificate, check for about $150 and their form filled out. When the surrogate's open, the people can just drive in and do it. The surrogate's offices, most of them are not yet open to the public, so we got to do this ahead of time through email and send them the original will. So when someone says, I want to get a trust done, I'll ask them why. My mother-in-law used to ask me every other year, I want to come in and get a trust done. And I would say, we watching Susie Orman. She goes, oh yeah, she smiles. Susie Orman is absolutely right if you live in New York, California, Florida, or a state where probate is very complicated. But New Jersey, ironically being the easiest state, I ask people, why do you think you need to have a trust done? You're not saving, because there's 2 types of trusts. One is a revocable trust, one's an irrevocable trust. A revocable trust is very popular and recommended in California, Florida, and New York, where probate's complicated. This way, instead of the person owning real estate property, it's owned by the trust, And that way, when the person passes, the trust can start writing checks the same day the person dies. But again, I ask people in New Jersey, why do you want to spend $3-4 grand or more when you don't need them? There's a different kind of trust called an irrevocable trust, and not only does that avoid probate, but the assets are no longer owned by you. So certain trusts, if more than 5 years go by, then the assets are protected from nursing home. But it got to be 5 years and a day. The person can't be the main trustee. They don't own the assets anymore. It's much more complicated. But if that's what people want to do, that's what people want to do. Let's see, and that's a person. Some people don't want to, give away everything they have. But it's better to spend the money to put into a trust than just give it away to your kids while you're alive. And why is that? Well, we just finished up a lengthy litigation case where this fellow who was in his 80s said, you know what, I got some money. I don't want to spend the money on this trust thing. I'm just going to give half to my son, half to my daughter. And then he does a new deed. Okay, half the house to my son, half to my daughter. Okay, everything's done. They get it. Well, I'd say no one would have predicted the son would have died. So now, who owns half of everything this guy ever worked for in his life? His ex-daughter-in-law. And the family sends a letter to the ex-daughter-in-law. Hey, will you do us a favor and give us all the money back and sign a new deed saying, oh, I'm transferring the assets back. Now, I represented the daughter-in-law. She goes, what do I have to do? I goes, tell him, you don't got to do anything. It's your, that was your husband's money. That's your money. So therefore, I tell people got, it's kind of like sometimes when you're younger, do you waste the money on life insurance hoping you don't die, or do you buy the life insurance? Let's say if someone has paid up their house, do you waste the money in homeowners insurance, or are you smart continuing having homeowners insurance? So I tell people that's one of the benefits of an irrevocable trust. Logistically, now, only the original will can be admitted to probate. So I tell people this, you want to make sure that you don't put it in a safe deposit box because it has to be where the executor can get to it. Especially what happened last March, April, and May of 2020. You couldn't even get into a bank to get anything out. They goes, hey, we're closed. You do your online banking. Well, we need to get into our safe deposit box. So most people just buy a fireproof box from Costco. They put the papers in it and make sure you close it. And it shouldn't have paper sticking out. I remember my wife had one of those fireproof boxes, but there's so many. It wasn't even like valuable paper. It was just envelopes and garbage that was sticking out. I goes, that's not fireproof. That's kindling. And but you want it in a place where your important documents can be get to on the weekend. A will is good forever. If you do a will in 2021, it's good 5 years from now. It's good for 20 years from now. We do recommend a new power of attorney be signed every 5 or so years, or if the people who are your powers have moved, or their names have changed, like women get married or unmarried, because if there's an emergency and the power of attorney needs to be used, a lot of banks might say, well, this is a different person. That's my maiden name. The bank would say, I don't understand, or there's a different address on this. We've already mentioned assets that pass by title. So the whole idea in doing trust is if you're doing an irrevocable trust, you're not owning the assets anymore. They're owned by the other person. And certain assets, before you just toss them into a trust, you got to think of, okay, let's say if it's an irrevocable trust, you don't own it anymore. There is a tax implication. And what is that? It's what's called, there could be a capital gains problem down the road. So, an example is, if you bought your house if someone bought their house in New Jersey in 1970 for $50,000, and now it's worth $450,000. That's a $400,000 capital gain, $400,000 profit. But if someone passes away, there's what's a step-up in basis, so there's no capital gain tax that has to be paid. See, but if you just transfer the house to a kid and the kid's not living there, when they sell it, they get the carryover basis of $50,000, so they're paying a capital gain on the difference between the $450 it's sold for and the $50,000 it's purchased for. Same thing if it's put into a irrevocable trust. Also, oftentimes people lose, if they're just giving away stuff, they lose like senior citizen benefits, any veteran benefits, things like that. So it's not something that you just want to rush into. Wills in New Jersey are not filed with the government anywhere until someone passes away. You know, people said you're going to file it. It goes, no, you're going to put it in your house. Some people have a clause. You know, some people have in their will what's called specific bequests. That means that specific monies are going to, you know, someone might say $10,000 to each one of his grandkids, or you know, $10,000 to a charity. Sometimes though it's better to have an amount than a percentage, because if it's percentage, then each one of those beneficiaries can ask for a formal accounting. And if it's like a charity and a charity's getting a percentage, it has to be noticed to the Attorney General, and the Attorney General would require a formal accounting. So some people want a child or spouse to live in a house for a period of time, so they're not kicked out. So we then would do what's called a life estate within the will. A life estate to stay in the house, but typically as long as they pay all the roof expenses, homeowners insurance, property taxes, like you know, maintenance, you know, minor repairs, cut the grass, things like that. After the will is signed, it's also a good idea to we tell clients you can do what's called a letter of instruction to the family. It's not a legal document, but it's just saying, listen, we did this, and these are my assets. Who should be notified? You know, some people even do pre-planning for a funeral now. And I remember, you know, I did it. Not that I'm planning on like leaving a plane fairly soon, but it's so my family is not. Yeah, a lot of times you don't want to seem cheap when you're at the funeral home, planning like you know, your spouse or like or mom's like you know doing the funeral. But you know, those places will sell you a gold-plated you know, diamond encrusted casket if you do it. So when I did it, I just, you know, it didn't cost me money. I just filled out the form at the funeral home. Okay, for me at least, let's say, you know, cremation, no detailed mass. But in my letter of instruction to the family, I put down, I want to have a big party at the Edison Elks Club, open bar, lots of sandwiches, anyone can go. Let's see. Now, I've been, a copy of a will cannot be admitted to probate by the county surrogate. Think of the county surrogate as the fancy name for the will clerk. If everything is perfect, you give it to them perfectly, they say, okay, fine, stamped, okay, yeah, you're in. But if it's not original, they can't act. Then we gotta file a complaint, order show cause, go in front of a judge. Then we have to send a notice to everyone on the planet that would have inherited without a will. The whole idea of doing planning is to make things easier. It's not about trying to save money, it's trying to you know, spend a couple of dollars so things are done faster. Let's see, there's no law that says you gotta change your oil every 5,000 miles or whatever, but if you didn't change your oil, then bad things happen. We do though recommend that the power of attorney be scanned and sent to you know, your agent, also to all the financial institutions. That way they have it. So if the power of attorney needs to be you know, used, so you can make sure that your the person's paying mom, dad, or Uncle Joe's bills, then it has to be done. So let's see, that's a little bit about wills. Now we're going to talk about the power of attorney. The power of attorney is a document that while you're alive, you're giving the power to someone in the family that you trust to be able to, again, make sure your bills are paid and act for you legally on your behalf. So it's an important document to have. For a lot of people, it's more important than the will itself, because the law in New Jersey is this: if someone passes, there's an order who gets it. On the other hand, if someone becomes disabled, even a spouse does not have the legal right to do anything on that person's behalf. So the power of attorney typically has clauses saying, listen, it authorizes one of the spouses to to act on my behalf. And I'll give an example why a power of attorney is recommended. One of my Edison neighbors said, listen, we're moving to Carolina, I need a power of attorney so I can sign for my husband at the closing of the house. Okay, when can your husband come in? Well, he can't, he had a stroke. Well, is he competent now? No, not really. He goes, well, then you can't do a power of attorney. Well, she goes, how can I sell the house? We got a buyer. He goes, legally you can't. As long as he's alive, without an order by a superior court judge, you can't sell the house. And I goes, but we have a buyer. He goes, listen, my job is not to tell you what you want to hear. I got to tell you what the law is. One of the reasons we try to do seminars to educate the public and tell our clients or friends, it's not because I make a whopping $100 on doing a power of attorney, it's because it's going to cost you thousands of dollars if you don't have the document. Once a week we get a call in my law office. It's usually one of the kids. I need to get a power of attorney over mom, dad, Uncle Joe. He goes, you can't get power of attorney over anyone. They have to formally sign the document giving it to you. Now, we try to help people out. We usually, we'll say, listen, you can help out mom or dad type up the form, but I need to talk to them, and they have to tell me who they want as number one, number two. They can't say whatever my daughter wants. So, let's see now. Our rule of thumb is who your agent should be is someone who can drive to the bank and can walk up a flight of steps. Let's see. If they can't do that, then they may not be the right person. I'm not anti older people or people that can't run a 100-yard dash. I try to be practical, because if someone can't get in the car and do the work, how are they going to do the work? So what are some of the things in the power of attorney? The ability to sell real estate, sign checks. We also revised our form in 2021 to have what's called a HIPAA authorization, so that the doctors are authorized to talk to someone. We also added what's called a designated caregiver pursuant to the New Jersey Act, designated caregiver under the Designated Caregiver Act, and also to make any medical decisions. Now, we recommend people do a separate living will advance directive, but we added that into our power of attorney. Now, why do I recommend a new power of attorney be signed every 5 years? Because banks give people a hard time. This is like when they see something that's 17 years old, they goes, how do we know that this person's this is still up to date? Now, a power of attorney is either effective right away or only upon disability. We usually recommend people sign the part where it says effective right away. That's so, because otherwise, if it's effective only upon disability, you have to go and convince the bank or financial place that the person is disabled. They're going to want affidavits of doctors, etc. Why do you want an attorney to do it right, not use a cheap thing online? Because a lot of the cheap things online don't have reference to New Jersey statute. New Jersey improved their Power of Attorney Act some years back. A lot of the banks were giving people a hard time. Well, we're not going to honor it because it wasn't done in our form. It wasn't done in our Wells Fargo form or whatever bank. So the legislature said, listen, if it makes reference to the New Jersey statute and they do business here in New Jersey, they have to honor it. However, the document has to make reference to section 2 of PL 1991 C95 C 46:2B-11, and I'm pretty sure these cheap things online don't have that reference to the New Jersey statute. I had a client last year. He goes, Ken, you're talking about effective only upon disability. Well, if it's effective right away, that's called a durable power of attorney. It's effective right away, stays durable if someone becomes disabled. A springing power of attorney only springs into effect if someone becomes disabled. So, Joe says, Kenny, listen, I don't understand legal stuff. I'm a carpenter. Explain to me in carpenter language what the difference is. And I goes, okay, let's see. If it's effective right away, your son can steal your money right away because he's your agent. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money. Knowing that, you trust your son. He goes, I trust my son, my life. Fine, just make it effective right away. We had a client, a couple years ago, for whatever reason, it's their decision, they made it effective only upon disability. Then there was a problem that, let's see, the guy was missing. I go, well, your power of attorney doesn't work because he's not disabled. So logistically, after you sign your power of attorney, you should have it scanned and sent to the financial institutions. That way it's on their, it's in their file. The last document we're going to talk about is the Living Will Advance Directive. Now, everyone, years ago, New Jersey had the Karen Ann Quinlan case that where, it recognizes like the family's ability to remove certain life support. And then the Terry Schiavo case went to the United States Supreme Court because in that case, the family, the husband, the doctors in the hospital said, listen, wife is brain dead. Okay, husband says remove the tubes. The family went to court and said, no, we oppose that. God's going to make her better, and it went to tens of thousands of dollars I had to spend in court costs and fees. The whole idea is to try to, say, listen, spelled out, this is what I want. So really, the document isn't for you, it's for your family so that they don't have to go through the trauma of the doctor asking them, okay, should today be the day? Because I remember when a doctor asked me that question. I'd say, yeah, because the person did not have a living will, okay, should today be the day? Meaning, should we remove life support and the person dies right now? And I remember saying to the doctor, geez, I feel bad. I mean, you know what the right decision is for someone who's 92 years old that's not going to open their eyes again and be able to walk, but you hate to be the one to say, okay, and I couldn't even do it for my first dog. I had to send my wife in because I said, no, I would just keep on. I already had spent $16,000 keeping that other dog alive, do treatments and stuff, and I go, let's see, it's gonna be, so, though, again, the whole idea is, it's done this way, if an issue comes up, all you gotta do is say to the hospital, listen, this is what the person decided in 2021 to respect their wishes. We took language from the State Medical Society Living Will. This way, doctors are familiar with it. So the first section is A, fluids and nutrition to be provided or withheld. Probably 85% of the people now say, listen, if there's no hope for me, I'm in a coma, irreversible condition, remove feeding tubes, stuff like that. It's different from the feeding tubes when COVID first came in, where someone could be a healthy 40-year-old person and they got to be on tubes and stuff like that until they got better. Section B deals with directives as to medical treatment, artificial machines, stuff like that. 99% of people say, listen, there's no hope, no artificial machines, etc. Let's see. Now, similar to your executor, your living will has a section that says, okay, let's say this is who my captain of ship is going to be in the event that I can't talk for myself. This is the number 2 person. And that's kind of important also because what sometimes happens is you get, sometimes there's the one kid that was always around helping out and doing stuff for mom or dad. all of a sudden, like, the parents in the hospital, and you get the kid that didn't live in New Jersey that comes in and barges into the hospital room and goes, okay, I'm in charge now. Well, the answer really is, no, you're not in charge because mom or dad did the living will, and this person's in charge. You're lucky you're even in the room. You should have been here for the past couple of years when we needed help. Tell you a quick story about the selections. Let's see. When I updated my living will when I was first married, this is 30 years ago. When you're first married, you're all lovey-dovey and stuff like that. My law clerks don't know about that stuff, but I do. Well, my wife said, I could never make the decision to remove life support. He goes, okay, fine. I'll just leave my father because he's logical like Mr. Spock. So 25 years later, we're redoing this, and she goes, okay, wait a minute. If you die, I get $850,000 on life insurance tax-free, and I never have to work another day in my life? Well, why don't we just pull the plug on you now? I get the money. I can stop working. I can stop driving to Marlboro High School every day and doing all that work. Now, after the living will is signed, you want to. It's a good idea to also scan that and number one, email it to yourself, spouse, and the family. This way, it's on the phone. So, in the event that there was ever, some type of emergency, the federal law requires that the hospital asks, hey, does the person have a living will? Well, the answer could be yeah. I have it on my phone. I can email you a copy. So that's an important document to have. Believe it or not, New Jersey probate is the easiest in the country. So after the will is probated, we send a notice of probate to the beneficiaries under the will. The executor obtains a tax ID number. They do it online. They open up an estate account at the bank. Bills are paid. Assets are liquidated. The house is sold. If there's a house, we still have to file an inheritance tax return, even if there's no inheritance taxes due. So we get the waiver. We got to file the inheritance tax waiver with the county clerk, and then the executor prepares an informal accounting. Typically, it's just sending the beneficiaries copies of the bank statements and a listing of what was spent, and most of the estates. And then the attorney prepares a document called the release and refunding bond. It's sent to all the beneficiaries to sign. After that, after we get that and we file with the surrogate's office, everyone gets their money. However, that's required. Let's say someone does not sign the release and refunding bond. Well, then the estate has to go through a formal complaint or to show cause to approve an accounting, and then the surrogate's office takes a percentage of the estate as a fee. So we try to avoid that. What we have done is when we mail out the release and refunding bond, we put in a letter to the beneficiaries to say, okay, you've previously gotten the accounting, you got to sign this in front of a notary and certify that you don't have kids or what you're, or that there's no child support owed. And as soon as we get that back from everyone, then everyone gets their money. If one person doesn't sign, then we got to send a letter to all the beneficiaries saying, okay, we got the release and funding bond in from everybody except for brother whatever. Okay, so that means until everyone sends it in, nobody gets their money, and we need that. We're now going to have everything delayed by months, half a year or more to have a formal court accounting. However, if brother X does sign, then that'll in front of the notary, that will expedite things. And by the way, here is the address, phone number, and email of the reluctant one. That way, they can all the beneficiaries can call and get on the phone and say, hey, listen, sign the thing so we can get our money. So that in a nutshell is New Jersey. They made in New Jersey they made it easier for people to get things done. Well, our office has made it easier where, people don't have to come in. If someone does wanna come and sign their documents, we're good on that too. I have my card that says I got my germ vaccines, I tape it to the end of my desk. But that's that. So with that, thank you everyone on in Facebook and TV land, and also the most important thing, if someone needs to have a will or documents done, call Ken Vercammen's office in Edison, New Jersey, 732-572-0500. Thank you.